The Supreme Court said no to Fire Chief Ron Hittle, but you'll definitely want to hear about the unusual step that two of the justices took. Hi, I'm Stuart Shepard, and this is First Liberty Live. Hey, would you take a moment and subscribe to us? You can do that on firstlibertylive.com up at the top of the page, or also if you're a YouTube kind of person, just subscribe to our channel there on First Liberty Live on YouTube. That way you'll know each time one of these episodes comes out. Thanks for doing that. Stephanie Taub is Senior Counsel and chairs our Marketplace group here at First Liberty Institute. Hi, Stephanie.
Hi, Stuart. Thank you for having me on.
I wish I had better news to have you on, but this is what we have to deal with in the work that we do. So first, let's talk about that bad news. Just this morning, the U.S. Supreme Court denied our request that they take up Fire Chief Ron Hittle's case. He's the fire chief in Stockton, California, who was fired for attending a leadership conference that just happened to be held at a church building. First, what's your reaction to that denial of that request?
Well, Stuart, of course, we're very disappointed. We had hoped that the Supreme Court would take this opportunity to grant justice for Fire Chief Ron Hittle. It's been a long time fighting this case, and we'd hoped that the Supreme Court would take this case to correct this problem that we're seeing over and over in the lower courts with these kinds of cases that are like Fire Chief Hittle's. And so we do have there is a silver lining here.
And even though I work here, one of my coworkers this morning asked me, this is the end of the road, right? This is where it stops. That is correct, right?
It is the end for Fire Chief Hittle's case, but it's not the end when it comes to fighting this important issue. So what happened was two of the justices granted an opinion, or they wrote an opinion dissenting from the denial of cert, which means they wrote an opinion saying that the Supreme Court really should have taken this case because of the importance of the issue here. And they believe that this is an issue that has created confusion, created chaos in the lower courts. They've used these terms in that opinion. And so we believe that it's inevitable that the Supreme Court is going to have to address this issue that is essentially preventing cases where employees have faced discrimination at work, preventing those cases from reaching a jury.
And because the Supreme Court literally gets thousands of requests each year, usually the denials look like this. There's a number on this side that's the docket number, and then the name of the case, and that's it. And there are pages and pages of those denials. But this one had that 9-page dissent added. And Justice Clarence Thomas goes on at great length in that dissent to explain how the McDonnell-Douglas case, the decision in that case, has resulted in judges at the very beginning of a case summarily just tossing them out of court. And he wrote, "I'm not aware of many precedents that have caused more confusion than this one." That's exactly what happened to Chief Ron Hittle, right?
Yeah, that's exactly right. So the McDonnell-Douglas case was a case from the 1970s, and it was originally intended to help the plaintiffs that were alleging employment discrimination. But over the years, it's become not just a test, it's become an obstacle course for plaintiffs to overcome in order to actually reach a jury trial. And so this is the problem that Justice Thomas's lengthy dissent really goes into. It points out all of the different judges that have said this is a problematic area of law that needs to be addressed and needs to be clarified. And so we strongly believe that this is harming employees of faith at work, and we will continue to fight. And we know that this is a case where, or this is an area of law where the Supreme Court will need to address this issue.
To help us understand this, if you would, without connecting it to any particular case, just describe for us how this would go sideways at the district court level if we brought a case concerning, an employment case concerning religious discrimination. What can happen there that is going so wrong that Justice Thomas wrote all this?
Absolutely. So what courts are supposed to look at is there evidence of discrimination? such that if you brought it to a jury, could they find that there was discrimination here? And so what this McDonnell-Douglas test does is it imports about 9 other things that you have to go through in order to answer that question. And so, and a lot of those aren't even asking that ultimate question. And so this is a sideshow that's caused so many pitfalls for employees of faith who are bringing their claims. And simply, so if you have evidence of discrimination, you're entitled to go to a jury, or at least you should be. And so this judge-created doctrine shouldn't stand in that way.
You used a phrase that Thomas uses in his dissent, and that is the answering the ultimate question. Explain what that means. When you read that as a lawyer, I read it as a regular human. I have no idea what he's talking about. So what's he getting at?
So the ultimate question is really the only question that the judge needs to decide at that point, because we have a system where we don't put all of the power in the hands of the judge. So the power is split between the judge and the jury. And so we give the juries the responsibility for deciding, okay, what actually happened here? And judges are really only supposed to answer questions of law about what's the proper test for these sorts of things. And so if there is a question of fact, that's supposed to go to the jury. It's not supposed to be taken by the judge. But this problematic case from the 1970s is causing judges to make that decision when it should be the jury.
That's a very helpful explanation. Thank you for that. It's becoming clear, and you mentioned this earlier, that this is something that's going to have to be decided at some point by the Supreme Court. And in fact, there was another case heard recently at the court, not one of ours, and one of the justices brought up this McDonnell-Douglas decision, and the attorney, not one of ours, brought up Ron Hittle's name in open court and said, "There, you've got this question before you right now." They are aware of this, and at some point they're going to have to figure out how they're going to fix this.
It's a common problem that's coming up in employment discrimination cases. You're absolutely right. In the Ames case just a few weeks ago, the Supreme Court justices essentially asked about or Justice Gorsuch asked about Hittle's, the question that was raised in our cert petition on behalf of Fire Chief Hittle. And so Gorsuch displayed what you can see written in the opinion that just came out this morning. He just wrote, or he was asking questions about the McDonnell-Douglas test. Why should we still use it? Is it appropriate, or is it distracting from really the ultimate question? Is there enough evidence of discrimination for this case to go to a jury?
You've been in this business for quite a while now concerning religious freedom in the courts. So you know more than most that this is a long road. We have many cases that are underway right now. Many of these have been in play for years and years. Help us understand that part of the work we do, that it doesn't happen as quickly as it does in a TV melodrama. These things take time, and they take a lot of resources.
Sometimes it takes 50 years, 60 years for these
Wow.
cases to get overturned. I mean, we've seen that our Bladensburg Cross case, in Coach Kennedy, we see the Bladensburg Cross case, it was chipping away at this terrible precedent from the 1970s in the Establishment Clause context. And then Kennedy just put the final nail in the coffin of that, the Lemon test. And so we've seen that over and over again. It takes time sometimes for these precedents to really make their way up to the court, for the courts to come around to see the logic of our position. So we believe that Justice Gorsuch and Justice Thomas will be vindicated, and that we're so profoundly disappointed for Fire Chief Ron that we weren't able to achieve that justice today. But we are hopeful that his struggle, his work that he's put into this, standing firmly for religious freedom in the workplace, that it will bear fruit. That maybe not in his case, but in a future case, that this precedent will be overturned.
I was just talking to Coach Kennedy last week. We're at the NRB gathering, which happened to be here in the Dallas area. And I shared with him the encouragement that you just mentioned, and that is that his case is having a ripple effect across so many other cases around the country that are way different than a football coach wanting to take a knee and say a prayer on the 50-yard line quietly by himself. it is having an impact in cases of all different kinds all over the country, and his name is on that. He's the one that won that.
Absolutely. And we've seen similar circumstances for our Faithful Carrier case, for example. There were other cases just a few years before trying to overturn the same precedent there. And there were dissents from denial that had one justice, two justices signing on. And then eventually we got the whole court. And in our Graf v. DeJoy, we got a unanimous opinion in favor of workers' right to religious accommodation.
One last question for you before I let you go. What keeps you going on a day like this? What keeps you stable and moving forward?
Well, we'll just continue to pray. We believe in what we're doing. We believe that we're fighting the good fight, and we put in our very best effort that we possibly could. And it's all ultimately up to God and up to His timing. So we'll just give it to God.
Stephanie, thank you so much for making time for us today. I appreciate you and appreciate the work that you do for First Liberty. You're an important part of our work here.
Thank you, Stuart.
If you want to see America's religious heritage defended, you can make that happen with your support of First Liberty Institute. Just look for the big red Give button up at the top of firstlibertylive.com. It's quick, it's easy, and we appreciate, let me just say thank you in advance from all of us here at First Liberty for helping us do the work that we do. You are an important part of this work, and let me just say that we appreciate you for that. First Liberty is fighting for what matters most.